Good morning, my name is Professor Errera and the name of my course is Speech in Context. This course will have two topics, speech and privacy and press privileges. Freedom of speech is a fundamental right, both under domestic law and under international human rights instruments. It is not, however, an absolute one. Hence the question, if it may at times be restricted, which rules will govern the balancing of competing rights, values and interests? Which ones? We may think of individual rights, such as protections against libel or against infringements of privacy. One might also mention societal values, such as the issue of group libel or hate speech, or the protection of the integrity of the judicial process. Coming to privacy, I shall examine it as an illustration of the rights of personality. The content and scope of this new legal notion will be examined and commented together with the place of privacy in it. We shall then explore privacy. First of all, should we define it? If so, how? But should we? In most legal systems, as we know, privacy is already protected by a number of instruments. What is then the added value, the utility of an affirmation of the right to privacy? Freedom of speech is not an absolute right, neither is the right to privacy. If we affirm such a right to privacy, what should be its exact scope and limits? If one thinks that privacy should be protected against infringement by the media, a question arises. Which are the defenses? Truth, the public interest, the notion of public figure or public event? Turning to some countries like Britain, France, Germany, the US, we shall study the attitude and response of their legal systems towards the affirmation of a right to privacy and the relationship between such a right and freedom of speech. If the Constitution is silent, if Parliament refuses to act, should the courts affirm such a right? If so, how? The recent case law of the European Human Rights Court will be examined in this context. Turning to press privileges, the course will address mainly the issue of the protection of journalist sources of information. This is not an easy issue leading to simple answers. On the one hand, it is true that systematic disclosure of the sources of information might undermine freedom of information and thus of speech. On the other hand, what about fair trial, equality before justice or before the law? Besides, granting immunities and privileges may create precedents and lead to demands from other professions. Here also we shall look at the case law of different countries and at that of the European Human Rights Court. In one word, I intend this course to be both of high level and a lively one, through the thorough discussion of leading cases and the use of comparative law and an exchange of views between us. I look forward to meeting you in my course. Thank you.